first, was the IEBC properly constituted to begin the process of undertaking voter registration? Well, that is one of the matters that the judges of the appeal court could not agree on, with the majority believing that it was not, and thus not legally capable of undertaking such a matter. While delivering judgments in the BBI appeal case, judges also noted that matters of procedure were not followed as per the law, as NTV's Leila Mohammed now reports.
Among the few issues that the Court of Appeal had within the BBI appeal case was whether the Independent Electoral and Boundaries Commission was properly discharged its verification mandate in line with the Constitution. Justice Gatembu Kairu says that IEBC publishing the list of supporters over a weekend was clearly in violation of IEBC's own time frame of 2 weeks. He notes that the time provided was grossly insufficient.
Why IEBC was in such a rush is not clear. Secondly, there is the question whether merely uploading the list on IEBC's website without more is sufficient. Would it have been more effective for IEBC to, in addition to uploading the list on its website, to publicize the matter in other media as well?
On the matter of public participation, the election body was called out for not fully complying with the law before receiving signatures for verification.
There is a legal requirement under Article 10 of the Constitution for voters to be supplied with adequate information to make informed decisions. There is no evidence that that was done in this case.
That the administrative procedures that were developed by the IEBC are invalid because they were developed without public participation by a commission that did not have quorum.
While the matter of the IEBC in not undertaking civic education prior to voter verification, the initial steps that would lead into a referendum, was prominent for one judge. For others, the issue was the constitution of the commissioners, which invalidates their actions. The bench had differing views on the same.
I reached the same decision as the High Court, that IEBC was not quorate when it embarked on the business of verifying the BBI signatures on membership of only 3.
Each commission shall consist of at least 3, but not more than 9 members. The IEBC, as currently constituted with 3 members, cannot be said not to be constitutionally compliant. And the question that I ask myself, if with 3 members, the commission is constitutionally compliant, in my view, I think the constitutional provisions take precedence.
Lady Justice Fatuma Sichale defended her opinion on why she believes the matter of quorum was not an issue in the case.
In my view, it cannot be said that in performing such mundane tasks as the continuous education of voters would require the Commission to be quorate, more so bearing in mind that the Commission has a secretariat that undertakes its day-to-day operations. I am therefore of the considered opinion that the verification of signatures was not null and void for lack of quorum, and neither was it a function that required a policy decision.
The Court of Appeal judges agree that the matter of public participation was not sufficiently exploited by all key players in the push for the constitutional amendment.
To be participation, and not just participation, there must be meaningful participation. So I'm in agreement with the learned judges that public participation is one of the principles of good governance, and that it's a constitutional right that must be complied with at every stage of a constitutional amendment process. And in particular, I have said that it's particularly crucial at the commencement of a popular initiative, because the people must have appropriate information regarding the initiative to enable them make an informed choice on whether to support the bill or not, on whether to support the initiative or not. And therefore, the adequacy of public participation at the outset is very crucial.
The IEBC has been urged to get clarification from all relevant quarters, including the Constitution itself, on its role and how to undertake such constitutional acts.
I find and hold that there is no constitutional or statutory requirement for the IEBC to carry out a nationwide voter registration before any proposed referendum, but the Commission is under a constitutional and statutory obligation to do a continuous registration of voters in each constituency.
So with these amendments, what next for the IEBC? What changes will be effected to earn public confidence ahead of the 2022 election? Leila Mohammed, NTV.